I was sitting in a parking garage in downtown Memphis, Tennessee, staring at a voicemail notification on my phone. I hadn't listened to it yet. I didn't need to. The number was Blount County Probate Court, and when a probate court calls you 7 minutes after your uncle's funeral ends, the conversation is never good. I had been waiting 14 months for that call. My aunt spent those 14 months telling everyone I had no claim to anything. She said it at the reception after the funeral. She said it to the estate attorney's assistant. She said it to my cousins at Christmas dinner 3 weeks before my Uncle Gerald died, when we all knew it was coming, and the circle around his fortune had already been drawn without my name inside it. What none of them knew was that I spend my professional life in courtrooms reading documents exactly like the ones they'd been hiding, and someone in that family had just made a very expensive mistake. What happened when I finally listened to that voicemail ended up reversing a $1.2 million estate distribution. But before I tell you that part, you need to understand how a family decides that one of their own doesn't deserve what they were promised, and what it costs everyone when the wrong person turns out to be a probate attorney. Welcome back to Drama Stories. I'm Nora. I'm 41 years old. This is the story of how my family erased my uncle's real wishes, and how a handwritten note tucked inside a King James Bible brought everything crashing down. If you've ever been told you don't belong in a room that was built for you, stay with me, leave a comment, and subscribe, because this one is going to take a minute. Most mornings, I'm in the office by 7:30. The firm sits on the 11th floor of a glass tower on Union Avenue in Memphis, Tennessee. Marble lobby, high ceilings, a coffee machine that costs more than my first car. Nothing humble about it, but I've never been comfortable with humble. I'm a senior associate at Caldwell, Merritt & Voss, one of the oldest estate litigation firms in Shelby County. Undue influence, testamentary capacity, forged documents, deathbed amendments made while a person was on morphine, and their signature looked like a child drew it. I've been doing this for 12 years. Before that, I spent 4 years at the County Public Defender's Office learning how to read people under pressure, how to find the truth in documents that are designed to obscure it, and how to stay calm in rooms full of people who are absolutely certain they are right and would rather die than be proven wrong. In the past 12 years, my cases have resulted in the reversal of 31 fraudulent will amendments. 9 of those involved family members who genuinely did not believe they were doing anything wrong. That's the one that always surprises people. The most effective financial predators in estate law are not cold-blooded. They are emotionally convinced. They believe the dying person loved them most. They believe they earned it. They believe the other family members never showed up, and therefore don't deserve to show up now. They can look a judge in the eye and cry real tears while describing the hours they spent at a bedside. And those tears are real, because the story they've constructed is real to them. I've sat across from 9 of those people. I've watched them cry, and then I've presented the evidence. The irony is that my own family had no idea what I did for a living. Not really. My Aunt Constance knew I worked at a law firm. She told everyone I was a paralegal. My cousins knew I went to law school. They assumed I'd washed out as something more prestigious. The one time my uncle asked me directly what kind of law I practiced, Constance was in the room and she answered for me before I could open my mouth. "Nora does contracts," she said. "Corporate stuff. Nothing interesting." Gerald had smiled at me over her shoulder, with the look he always gave me when Constance answered for him too. I didn't correct her. In my line of work, the moment someone knows what you're looking for, the document disappears. My Uncle Gerald Harlow was my mother's older brother. He was 71 years old when he died, and he'd spent 40 of those years building a land development business in West Tennessee that at its peak owned 14 commercial properties across 3 counties. Gerald never had children. He married Constance Harlow, née Pruitt, when he was 39 and she was 34. They were together for 32 years. I'm not going to tell you Constance was a villain from the beginning, because that's not what happened, and it's not the kind of story I want to tell. What I can tell you is that Constance was a woman who believed, with complete sincerity, that she had earned every dollar of what Gerald built, because in many ways she had. She decorated the offices. She handled the social calendar. She attended every business dinner, every Chamber of Commerce banquet, every charity gala where Gerald needed someone on his arm who could make conversation with the mayor. She also, in the last 4 years of Gerald's illness, took over all of his financial correspondence. She managed the household staff. She drove him to his oncology appointments. She read to him from Louis L'Amour novels in the evenings, because his eyes were going and he missed being able to read for himself. By the time Gerald was in the final stages of pancreatic cancer, Constance had become both his caretaker and his gatekeeper, and those two roles are not always compatible. I should know. I've built 31 cases on that exact incompatibility. The last will and testament of Gerald Harlow had been executed in 2009. I know because Gerald told me. He called me on a February evening, 6 years before he got sick, while Constance was at a charity benefit in Nashville, and he talked for 45 minutes. That was unusual. Gerald was a quiet man. He expressed affection through actions, not words. He paid my law school tuition. He didn't say much about it. When I passed the bar, he sent me a handshake and a check for $3,000 with a note that said, "You earned it, kiddo. Don't spend it on furniture." He was not a man who called to talk. He called to tell me that he had updated his will, that he had left me a 30% share of the estate, which at the time amounted to approximately $400,000, not because I needed it, but because my mother, his sister Pauline, had died the year before of a stroke, and he wanted to make sure someone from Pauline's line was included. He had also left 30% to the University of Memphis Foundation for a scholarship endowment in my mother's name. The remaining 40% went to Constance. He made me write it down. "Gerald," I said, "I'm an estate attorney. You don't have to read me your will." "I know what you do," he said. "That's exactly why I'm telling you. Write it down." So I wrote it down. February 14th. I still have the notepad. I asked if he'd told Constance about the distribution. There was a long pause. He said Constance understood that family came first. Then he laughed a little, the quiet, dry laugh he had, and said, "She doesn't love the number, but she understands." I should have pressed harder on that. I know that now. Gerald was diagnosed with pancreatic cancer in the fall of 2020. Constance called me to tell me, and she was composed and detailed in the way people are when they've had time to prepare what to say. Stage 3. Surgery wasn't viable. Treatment options were being discussed. Gerald was resting. I drove down to Germantown the following weekend. Constance met me at the door with a list. Gerald was tired. Gerald needed quiet. Gerald's doctor had said stimulation set back his rest schedule. I could see him for 20 minutes, and she would need to be present, because Gerald sometimes confused himself, and she didn't want him distressed afterward, trying to remember what he'd said. I sat with Gerald for 19 minutes, with Constance in the armchair by the window, doing her crossword. He looked smaller. Not thinner exactly, just condensed, the way illness compresses a person. He held my hand and asked about my cases. I told him I had 3 contested wills in the pipeline and 1 that was going to trial. He nodded and said "good girl" the way he always had, even now that I was 40 years old, and it made my throat close up the same way it always did. As I was leaving, he gripped my hand tighter for just a second. He didn't say anything. He looked at me with those pale blue eyes that were still completely sharp, whatever the illness was doing to the rest of him. And he held on for 1 extra beat. Constance was in the hallway with my coat. I thought about that grip for a long time afterward. The phone calls started to change 3 months after the diagnosis. Gerald and I had always had a rhythm. He called on Sunday evenings after the news, from the study at the back of the house, where Constance didn't like to sit because it smelled like cigars, even though Gerald hadn't smoked in 12 years. Those calls ran 20, sometimes 30 minutes. Land, business, my cases in the abstract. Whether I was eating enough, which he asked every single call without variation for 12 years. Then the calls shortened. 10 minutes, 8, 5. "Constance is coming in, sweetheart. I'll have to let you go." I started tracking it, the same way I track patterns in documents. Not from suspicion, from habit. The calls only came on Sunday afternoons, between 2 o'clock and 2:45, which was when Constance went to the garden. Outside that window, nothing. He didn't have his own cell phone. The house landline went through the kitchen, where Constance spent most of her time. One Sunday in the spring, 14 months before he died, Gerald said something that made every professional instinct I had go quiet and cold. He said, Nora, I've been wanting to ask you something. About the will. Whether something can be changed without the original attorney present. I kept my voice even. That depends on the change, Gerald. What are you thinking? Constance walked in. I could tell by the shift in his voice, the word gap, the small recalibration. Never mind, sweetheart. Let's talk Sunday. We didn't talk that Sunday, or the following one. The following Monday, I was back at my desk, reviewing a contested amendment case in Lauderdale County. An 80-year-old retired school teacher, whose stepson had presented a handwritten codicil 3 days before she died, witnessed by the stepson's wife and the stepson's college roommate. The original will had left the house to a local animal shelter. The codicil left it to the stepson. The signatures on the witness's identification didn't match their state ID signatures by 11 distinct points. I built the handwriting analysis file in 3 days. Presented it to the court on Friday. The judge vacated the codicil. The shelter got the house. I drove home that evening and sat in my kitchen with a glass of water, going warm on the counter, and thought about Gerald asking me whether something could be changed without the original attorney present. In 12 years of estate law, that question has one common source. Someone is trying to cut out a beneficiary without going through the channels that would generate a paper trail. I hadn't said it to myself directly yet. I was still giving family the benefit of the doubt I would never give a stranger. But in my notebook, on the page I opened for every new matter, I wrote his name, the date, and the question he'd asked. Then I wrote below it the words I always write when a pattern starts to form. Preserve everything. Trust nothing verbal. 6 months later, I drove down to Germantown unannounced. I'd stopped calling ahead after my 4th attempt to visit had been met with some version of Gerald's resting, or Gerald's with the doctor, or Gerald's asked not to be disturbed until Thursday. 4 attempts over 8 weeks. I kept notes of every one, dates and times and the exact language Constance used each time. I knocked on the front door at 10 a.m. on a Thursday. Maria, the housekeeper who'd been with Gerald and Constance for 19 years, answered the door. She looked at me, then back over her shoulder, then at me again, and stepped aside without being asked. Constance came down the stairs before I made it to the hall. She was dressed, hair done, the way Constance always was even at 10 in the morning. Her face did something complicated when she saw me. Not anger, not quite. Something practiced over anger. Nora, you should have called. I called 4 times in August. Gerald wasn't available. He has good days and bad days, you know that. I'd like to see him. She paused, the pause of someone calculating something quickly. He's resting. Maria was still in the hallway. She didn't move. Her eyes were on the floor. I said, I'm going to sit in the front parlor until he wakes up, if that's all right. I brought him a book. Constance looked at the book in my hand. Cormac McCarthy. Gerald loved McCarthy. She looked at me. An hour, she said, and I'll need to be in the room. I sat for 90 minutes. Gerald slept for the first 40. When he woke up, he saw me across the room before he saw Constance, and the expression on his face was something I can only describe as relief, the way a person looks when they see someone arrive who they weren't sure was coming. We talked about the book for 20 minutes. Constance interjected twice. When my time was up, and I stood to leave, Gerald took my hand again, the same grip he'd used 8 months before, harder this time. His eyes were still completely sharp. He pressed his thumb against my knuckle, twice, quick, deliberate. It was the same gesture he'd used to teach me Morse code when I was 9, our private alphabet. 2 short presses, the letter I. I didn't react. I kissed his forehead and said I'd come back soon. Constance walked me to the door. I noted the time in my car before I put the key in the ignition. In my notebook I wrote, 2 presses, as in I need. The next Sunday, the call came at 2:10. Gerald's voice was lower than usual, flatter, the deliberate flatness of someone measuring every word. Nora, I need you to know that whatever you see in the coming months, the original document exists. I want you to remember where I keep my important papers. The study, I said. Filing cabinet, bottom drawer. No, he said. Not anymore. Constance's voice came from somewhere close. Gerald, your 3 o'clock is here. Think about the attic, he said, and the call ended. I sat with the phone in my hand for 4 minutes. Then I opened my notebook and wrote the date, the time, and 4 words. Attic, original document exists. If you've ever listened to someone you love try to tell you something without being allowed to say it, you know that those are the 4 words you hold on to. You hold them until you can do something with them. Gerald died on a Thursday morning in October. Constance called me. She was composed. The funeral would be Saturday at Second Presbyterian. The family was gathering at the Germantown house afterward. She hoped I could make it. I made it. I sat in a pew 3 rows behind Constance and her 2 nieces, Meredith and Dana, who had been at the house every weekend for the last 6 months, both of whom I knew worked in property management and had been helping Constance manage Gerald's real estate portfolio since he'd become too ill to do it himself. After the graveside, there was a reception at the house. 60 people, catered, white linen, the usual architecture of grief and duty. I accepted a glass of water and talked to Gerald's former business partner Lyle for 20 minutes, and watched Meredith and Dana work the room with the quiet authority of people who already know what the will says. She had the specific energy of someone delivering news they've been rehearsing. The estate is in order, she said. Reginald Voss has the documents. Reginald Voss was an estate attorney out of Memphis, no relation to my firm's Voss. There will be a reading next week. I want you to know that Gerald made some changes in his final year. He wanted the estate concentrated, so the business assets wouldn't have to be split across parties who aren't involved in the operations. I looked at her. What kind of changes? He felt it was simpler, she said, to consolidate. I said, I see, and went back to talking to Lyle. In the bathroom upstairs, I called my paralegal Denise and told her to start everything publicly recorded for Gerald Harlow's estate. Then I stood in the bathroom for 2 minutes with the water running, doing what I do before every important moment in a courtroom. Breathing, thinking, getting quiet. Gerald's study was empty when I came back downstairs. The party had shifted to the dining room. I had 2 minutes, maybe 3. I went to the study door and put my hand on the frame. The filing cabinet was in the corner. Bottom drawer, where his important papers used to be. Now, Gerald had said, not anymore. I looked at the ceiling. The attic pole was in the hallway. I didn't have time. I went back to the party and had a second glass of water, and waited for the voicemail from Blount County Probate Court that I knew was coming. It came 7 minutes after the last guests left. I sat in the parking garage on Union Avenue and played the voicemail on speaker, writing while I listened. Reginald Voss's office, calling to inform you that you have been named as a contested party in the estate of Gerald Harlow, pursuant to a will amendment dated March of the prior year. Your bequest has been removed from the estate. The amendment also removes the University of Memphis Foundation bequest. The revised distribution leaves the full estate to Constance Harlow. You have 30 days to respond. I played it twice. Then I set the phone on the passenger seat and looked at the concrete column in front of my car for a long moment. 1.2 million. The entire estate. Every property, every account, every asset Gerald had spent 40 years building. All of it, by way of a document dated March of this year, when Gerald had been on chemotherapy and his hands shook on good days, and he could not reliably hold a pen on bad ones. I called Denise. I said I need everything. Execution date, witnesses, notary, the attorney of record. And I need the original 2009 will on record, if it was ever filed with the county. Then I drove back to the office. It was 6 p.m. on a Saturday. I was there until midnight. The March amendment was executed at the Germantown house, witnessed by Meredith Pruitt and Dana Pruitt, Constance's nieces, notarized by a notary whose name I ran through the Tennessee Secretary of State directory and found active, so that was clean, at least superficially. The original 2009 will had been filed with Gerald's estate attorney, one Calvin Deutsch, who had since retired, and whose files had been transferred to a successor firm in Collierville. I called that firm Monday morning and explained who I was and what I needed. They pulled the file. Calvin Deutsch's record of the 2009 will confirmed everything Gerald had told me on that February phone call. 30% to Nora Harlow, 30% to the University of Memphis Foundation Endowment, 40% to Constance. The March Amendment eliminated both outside bequests entirely, full estate to Constance. I pulled Gerald's oncology records through our medical record request process. The attending physician's notes for the week of the amendment's execution date were detailed, as oncology notes tend to be. Gerald had been in the 4th cycle of a chemotherapy protocol that carried documented cognitive side effects. His notes from that period included the phrase, patient occasionally disoriented, and patient required prompting to recall previous conversation. The week before the amendment, his dosage had been increased. I pulled the notary's records through the state database. The notary was clean, licensed, active, no disciplinary history, which meant either the notary had done their job properly, verifying identity and signature in person, or the notary had signed off on something they shouldn't have. That distinction would matter later. Then I called the handwriting analyst I use on contested document cases, Dr. Patricia Wen out of Nashville. I emailed her 3 samples of Gerald's signature from 2009, 2016, and 2021. I asked her to compare them to the signature on the March amendment. She called me back the next morning. Her voice was careful in the way that means what she's about to say is significant. Nora, the 2021 sample shows consistent age-related degradation. That's expected. But the signature on your March document doesn't degrade the same way. The pen pressure is too even, the baseline is too stable. A hand experiencing chemotherapy-related tremor does not produce this line. I'd need the original to confirm, but from the scan, this is not consistent with what I'd expect from the signer in this condition. I wrote it down. Then I called my supervising partner Harriet Caldwell and told her I needed to self-refer a contested will matter. She asked if I was involved as counsel or as a beneficiary. Both, I said. She was quiet for a second. Conflict of interest. I know. I'm requesting that Marcus Webb lead. I'll provide initial intelligence and step back from direct case management. Marcus Webb was the best contested will litigator at our firm, possibly in the state. Methodical, unflappable, and capable of delivering devastating cross-examination with the affect of a man discussing the weather. Harriet said, "How long have you known?" I looked at my notes. The February call, Gerald's question about changing a will, the grip at the goodbye, 2 short Morse taps. Suspected? About a year. I looked at the stack of documents on my desk. 31 reversals in 12 years, and every one of them had felt like surgery, precise, professional, necessary. I'd never once cried over a case file. "I'll be fine when we find what Gerald hid in the attic," I said. The motion to contest was filed within 30 days of the voicemail. Marcus led. I provided everything I'd assembled. The handwriting analysis, the oncology records, the witness relationship chart, which showed that both witnesses to the March amendment were Constance's nieces, one of whom had been named in the amendment as beneficiary of a specific art collection, valued at $85,000. A witness who stands to inherit under the document they witness has a conflict that undermines the validity of the witnessing. Tennessee Code on will contests is specific. We were moving on undue influence, testamentary incapacity at the time of execution, and interested witness disqualification. Constance's attorney was a man named Theodore Blanks, known in Memphis estate circles as Ted Blanks, which most of us found appropriate. He was competent, experienced, and very expensive. He filed a motion to dismiss on the grounds that the amendment had been properly executed and notarized. Judge Ellen Ferris denied the motion and set a preliminary hearing. Marcus presented the handwriting analysis. Dr. Wen was expert and precise. She outlined 9 specific indicators of inconsistency between the March signature and the expected degradation pattern. Blanks challenged her methodology. She dismantled his challenge point by point without raising her voice. The judge ordered the original document preserved and a subpoena issued for Reginald Voss's full file on the amendment, including any draft communications, the notary log, and any correspondence between Voss and Constance or her nieces in the 90 days preceding execution. Voss's file was thick. Most of it was standard, but one email thread dating from February of that year, 2 months before the amendment was executed, changed everything. The thread was between Constance and Reginald Voss. Constance's first email read, "Gerald is not going to be with us much longer. I want to understand the mechanics of a codicil versus a full amendment. If Gerald is unable to attend your office, can the document be executed at the house?" Voss's reply confirmed that in-home execution was possible and outlined the requirements: a licensed notary, 2 disinterested witnesses. Constance's reply: "Thank you. I have 2 people in mind for witnesses." 2 months later, those 2 people were her nieces, one of whom received $85,000 in art. Marcus added the email thread to the evidence file and sent me a single text that evening: "We have it." But we didn't have the original 2009 will in physical form. We had Calvin Deutsch's file copy and the client copy Gerald had presumably kept. The original, as Gerald had told me, was no longer in the filing cabinet. It was in the attic. 3 months into the legal proceedings, I drove to the Germantown house alone, not as counsel, as family. The house was still technically Constance's pending the contest, but she had moved to stay with Meredith in East Memphis during the litigation. Maria, the housekeeper, was managing the property. I had called Maria the week before. I told her what I was looking for and why. She was quiet for a long time. Then she said, in the careful voice of someone who has been waiting for permission to say something, "He asked me not to let them in the attic. About a year before he passed. He moved some boxes up there himself on a good day, and he told me if anyone asked, nothing of value was stored up there." I drove down on a Saturday morning. Maria met me at the door. We didn't talk much. She showed me to the attic pole in the second-floor hallway. The attic was a full floor, organized the way Gerald organized everything. Methodically, labeled, preserved. Holiday boxes on the left, business records going back to 1989 on the right. In the far corner, behind 2 boxes labeled Pauline's Things, which were boxes of my mother's belongings that Gerald had saved after she died, was a fireproof document box. Inside the box, the original 2009 will, signed by Gerald Harlow, witnessed by Calvin Deutsch and Calvin's assistant, notarized, complete, every page intact, every distribution exactly as Gerald had told me on that February phone call. 30% to Nora Harlow, 30% to the University of Memphis Foundation, 40% to Constance. Behind the will, in an envelope sealed with Scotch tape and marked only with my name in Gerald's handwriting, was a single sheet of paper, handwritten, dated 8 months before he died, in the deliberate blocky print he used when his hands were bad and he needed the letters to be legible. The note read, "Nora, if you're reading this, you found what I hid. I knew you would. I've asked Constance 3 times to honor the original will. She tells me it's already been handled. I don't know what that means, and I'm not well enough to fight it myself. But I know you. I know what you do, and I know you're better at it than anyone I've ever met. Your mother would have been so proud. You were always the one who showed up. The money is yours and the university's, because that's what I decided, and nobody changed my mind. I want you to fight this. I know you will. With love, Uncle Gerald." I sat on the attic floor next to my mother's boxes for a while. The afternoon light came through the one small window. Dust moved in it the way dust does. I held the letter without reading it again. Then, I took photographs of everything, placed the original documents in an archival bag I'd brought in my bag, because I am, after all, an estate attorney. And I called Marcus. "We have it," I said. The hearing reconvened 6 weeks later. Judge Ferris reviewed the original 2009 will, Dr. Wen's full analysis comparing the March Amendment signature to the authenticated 2009 signature, the oncology records, the Voss email thread, the interested witness chain, and Gerald's handwritten letter. Theodore Blanks argued that the 2009 will had been superseded by the valid amendment. Marcus argued that the amendment was invalid on 3 independent grounds: testamentary incapacity at execution, undue influence by the primary beneficiary who controlled all access to the testator, and interested witness disqualification. The judge gave Blanks considerable time. She let him make every argument. She asked careful questions. She was thorough in the way of judges who have made up their minds and want the record to be unimpeachable when they do what they've already decided to do. Then she ruled. The March Amendment was found to be invalid on the grounds of testamentary incapacity and interested witness disqualification, 2 independent grounds. She did not need to reach the undue influence question. The 2009 will was reinstated as the governing document of Gerald Harlow's estate. The courtroom was small, and there were not many people there. Constance sat at the other table in a gray suit. When the ruling was read, she did not move for a long moment. Then she looked at me, not with hatred, not with shock, with something that looked like exhaustion, the long tired look of someone who has spent a long time carrying something heavy and has finally been asked to set it down. I looked back at her. I thought about what Gerald had said. She doesn't love the number, but she understands. I don't know if she understood at the end. I know she loved him. I know she believed, truly believed, that she had earned it. I know that love and belief are not defenses in a court of law, but they are explanations. Sometimes an explanation is the most honest thing you can offer. 4 months after the ruling, the estate distribution was finalized. The University of Memphis Foundation received their endowment. The scholarship bears my mother's name. I attended the foundation board meeting where it was announced. I sat in the back row and thought about the fact that my mother never went to college. She raised a daughter who became an attorney who made sure her name would be on a scholarship that will send other people's daughters through school for the next 100 years. Gerald would have liked that math. My share of the estate went into a trust. I have not spent any of it yet. I'm not sure I will for a while. Some money doesn't feel like money for a long time. It feels like proof of something. A document you keep in a file box and look at when you need to remember that the right thing happened. Meredith and Dana were not charged. The investigation into the notarization found no evidence that the notary had acted improperly. The conclusion was that Gerald's presentation in person on a good day had appeared legally sufficient, and the notary had done what notaries do. The question of who drafted the amendment and the legal weight of Constance's emails remained civil matters, addressed in the probate case, and not referred to the DA. Constance received her 40%. She moved to Savannah, where her sister lived. Maria, the housekeeper, sent me a card at Christmas, with a note that said simply, "Mr. Harlow always said you were the smart one. I thought you should know." I put it in the file box with Gerald's letter. There is a cousin of mine, Darcy. She's Gerald's youngest niece on a different branch. She came to me 6 months after the ruling, sat across from me in my office with a cup of coffee she didn't drink, and said, "I always thought Constance was right about you, that you were difficult, that you made everything adversarial." She paused. "I want to apologize for that." I told her I didn't need an apology. Then I told her to drink her coffee. She said, "How did you know he'd left something in the attic?" I said, "He told me." She looked confused. Constance said he couldn't communicate clearly in the end. He couldn't communicate the way Constance understood communication. I said, "But he and I had a different language." Darcy thought about that for a moment. Then she said, "What did he say?" "2 taps, I said, in a code we built when I was 9. She looked out the window. The afternoon light was coming in sideways the way it does in October. He was asking for help. He was telling me he knew help was coming. There is a difference. Gerald knew. He knew before I did that I would find the box, read the letter, file the motion. He knew because he'd spent 40 years watching me, the way people watch someone they trust completely, with the particular intention of someone who has decided, without saying so, that this is the one. He called me the Sunday before he went to the hospital for the last time. 2 minutes, because Constance was in the next room. He said only one thing, in the quick, low voice he used when he was measuring every word. "Don't let them tell you what you're owed," he said. "You already